5 seconds to go. Start. The common law principles, which are law within the meaning of Article 13 of the Constitution of India, are saved in terms of Article 372 when Parliament or state legislature makes an enactment. The same would prevail over the common law. Hence, the common law must yield to statutory provision. Respondent 2 borrowed a sum of rupees 51 lakh from the first respondent financial corporation by an indenture of mortgage executed on 22nd December 1986. The said mortgage was governed by the provisions of the State Financial Corporation Act. The second respondent also owed a sum of rupees 19 lakh by way of central excise duty for the period April 1983 to May 1988. Again, respondent number 2, having committed default in repayment of the principal amount of loan as also the interest accrued thereon, the first respondent invoked Section 29 of State Financial Corporation Act and took over the actual physical possession of the mortgaged assets. Since respondent number 2 also owed a certain sum of money to the central government in the form of central excise rules, the said government expressed its intention to attach and seize its properties. The first respondent communicated to the government that it had the first charge over the properties mortgaged in its favor. Despite the same, the central government intended to proceed to recover the amount from the said properties. The first respondent, by its lawyer's notice, called upon the government to desist from taking any action against its securities and to remove the seal, if any, from the properties of the borrower. As the appellant government did not respond thereto, a writ petition was filed. The dues of the first respondent corporation will have priority over the central excise dues. The High Court, upon consideration of a large number of decisions, opined that despite the fact that the dues of the appellant government were recoverable as land revenue in terms of Rule 213(2) of the Central Excise Rules, read with Section 32G and Section 151 of the Maharashtra Land Revenue Code 1966, the same by itself would not mean that a first change of the financial corporation would give thereto. Aggrieved thereby, the government preferred the instant appeals, contending that the crown debt and in particular arrears of tax will have a priority over all debts, and in that view of the matter, the impugned judgment of the High Court was wholly unsustainable. Generally, the rights of the Crown to recover the debt would prevail over the right of a subject. Crown debt means the debts due to the state or the king, debts which is a prerogative entitles the Crown to claim priority over all other creditors. Such creditors must be held to mean unsecured creditors. The principle of crown debt as such pertains to common law principle. A common law, which is a law within the meaning of Article 13 of the Constitution, is saved in terms of Article 372 thereof. Those principles of common law thus which were existing at the time of coming into force of Constitution of India are saved by reason of the aforementioned provision. But when Parliament of a state legislature makes an enactment, the same would prevail over the common law. Thus, common law principles which was existing on the date of coming into force of Constitution of India must yield to a statutory provision. Stop.